council clerk will call the public hearing. We will then have a brief presentation by Councilor Eichelberg, followed by public comments. Roxanne, would you call the...
The Ledyard Town Council will conduct a public hearing at 6:15 p.m. on Wednesday, January 9th, 2013, in the Council Chambers, Town Hall Annex, 741 Colonel Ledyard Highway, Ledyard, Connecticut, to receive comment on the proposed Town of Ledyard Light Ordinance. At this hearing, interested persons may appear and be heard, and written communications will be accepted. Copies of the draft ordinance are available in the Town Clerk's office during regular business hours, dated at Ledyard, Connecticut, the 17th day of December 2012. For the Ledyard Town Council, Linda C. Davis, Chairman. It's published in the New London Day on December 13th.
Thank you. Councilor Eichelberg.
Okay. At this time, I want to give, I'm not going to go into a lot of detail, but I want to give a little summary, address some concerns, maybe allay some fears. If you had a chance to read the Patch article, you'll notice that there were some comments in there of folks who might be concerned or more concerned than is necessary about this blight ordinance. Let me say what we did with this. We wrote the ordinance very high-arcing. We very deliberately tied our hands to Connecticut general statutes, which, if you have an opportunity to read those statutes, you'll see that they are very well defined. They very much limit what towns can and cannot do with a blight ordinance. Nobody's going to be out there measuring your grass. Nobody's going to be out there checking your hedges. So again, we wrote this very general so that we would be very liable to what the Connecticut general statutes are, and to allow the commission itself some leeway in creating its own charter, which we as a town body will of course have to sign off on and make sure that it's in the best interest of the town. So this ordinance itself is, I'm going to use the word innocuous as far as the things that it intends to do. We are in receipt of Mr. Treaster's correspondence. We are also in receipt of editorials from the town attorney. We have done our best to take those into concern, into our deliberations, with the same intent of keeping it as high level as possible, so that, again, the actual commission can define its charter, and again, so that we will be tied to Connecticut general statutes. Let me address this real quickly. On October 1st, what was that? PA 12? Is that it? I don't have it right in front of me. Public Act 12-146 modified the Connecticut general statutes for blight ordinance. We did take that into account. We incorporated the things that were necessary from there on the advice of the town attorney. So we have modified it slightly, and all it really does is elaborate items that were already in the ordinance. So.
Thank you. Let me just also add, if I might, that we began this process several years ago, and this is our, I believe it's the third public hearing we've held on it, and it has been through both committees of the council and through the town attorney. So at this time, I would move on to public comments. I would mention that we have written communications from Mr. Treaster, and everybody here has received a copy, some of us 4 times, but most of us 3. And at this time, Mr. Treaster, would you like to add anything new to your comments?
I would, but I might go over the 5-minute limit.
Well, if you would go now, so then we know how much time we have left. So if you would do that right now, that would be helpful.
Thank you.
I wouldn't expect that you're going to repeat anything that we've received. Thank you.
Good evening. As you know, I've retired from the zoning commission and I have too much time on my hands.
Oh, I'm glad you said that before I did.
This will teach the council to get rid of the commission. Yeah, I'm just kidding. Anyhow, I took a close look at the proposed ordinance. And, when I looked at it, I was not aware of the history. But I tend to enjoy analyzing technical documents. And in my opinion, just my opinion, the proposed ordinance has some serious deficiencies. The proposed ordinance appears to be limited, appears to ignore the fact that the enabling statutes limit the blight ordinance to just housing. And so I think that's important. The blight ordinance can only be applied to housing. In my opinion, the proposed ordinance needs a formal finding section. It needs a formal authority section. In my opinion, the definition of blight is too fuzzy, and it also establishes a threshold that is too low. It is too easy to conclude that a building with one or two broken windows constitutes blight. I think the threshold should be higher. The time periods that are in the proposed ordinance, it mentions 21 days. 21 days is not in the enabling statutes. That the time periods that are in the draft ordinance clearly conflict with the enabling statutes. The authority and duties of the blight enforcement officer should be clearly described. Its references to the building code for the definition of abandonment is in error. It fails to require residents to maintain the property. There should be an order someplace in the ordinance that simply says that there is a duty for Ledyard residents to maintain the property. It provides for a 3-person blight hearing officer, which is permitted by the enabling statute, but it does not address what happens if one of those 3 people is absent for a hearing and there is a tie vote. The content of the blight citation is incomplete. Statutes require that there be additional mandatory content in the blight citation. The sections, the numbered sections in the ordinance are poorly titled. The draft fails to have an easy-to-understand severability section. It should have a section titled severability, which it does not. One of the more important deficiencies is that Section 5 implies that the court can order correction of the violation. However, the enabling statutes do not provide that authority. Now, admittedly, a judge can do anything he wants to do, but he can do that whether or not the ordinance says that. But the enabling statutes are silent on as far as correction of the violation is concerned. I cannot find anywhere where the enabling statutes can mandate the correction of the violation. All it can do is collect penalties, the fines, and that is the strength of any citation, is the punitive nature of fines and penalties. If somebody chooses to blank and they can pay the fine, they get to keep their blight. Is my interpretation of the ordinance and the enabling statutes. I took a look at the minutes of the last meeting where this subject was addressed, and I bumped into something called Public Act number 5319. And I don't know if that's the same Public Act that you were referring to. The number is different, but I don't know if it's the same content. But in any case, Public Act number 5319, which was approved late last year, and my comments here are not in what you have on IQM2, and it's not in the email that I sent to you. Public Act number 5319 requires that the occupants of the blighted structure be notified, as well as its owner. And that is omitted in the draft. It requires that fines be retitled, and all of the fines have to be renamed as civil penalties.
Eric, that is in Public Act 146, which is incorporated.
the word fine shows up in multiple instances in the draft.
In the draft as edited by the lawyers' editorials, it does not.
The one that I looked at online, the one that was referenced for this public hearing, which is what I use for my baseline, uses the word fines extensively. 5319 requires that the ordinance must provide for a reasonable opportunity to correct the blight. Those words are missing. And one of the more interesting things about 5319 is that if the town should choose to do so, it could specify a fine or a penalty of $250 per day for the blight. And if it does that, it bypasses a hearing officer. It goes directly to the state for enforcement, directly to the court if the owner wishes to appeal and the town does not get involved. It's very tempting to incorporate that into the ordinance. In the draft, in the ordinance that I prepared as an alternative for your consideration, it does not include that possible option. What I'm passing out is an update to a candidate blight ordinance that I prepared, which is slightly different than what I prepared on IQM2. The Public Act 5319 requirements are in italics in this document. What I just passed out addresses and resolves every one of my concerns. It does make some assumptions. It makes assumptions that one hearing officer will be sufficient. Obviously, you may want to go with three, as originally proposed. The advantage of one is you don't have to worry about typos. You don't have to worry about what happens if one member does not attend the hearing. There are all sorts of advantages for having just a single hearing flight hearing officer. It addresses all of the mandatory requirements in 5319. It suggests $25 per day per violation, which sounds similar to what was in the draft ordinance. However, the draft ordinance is fuzzy because the way it defines blight is that if it's a fire hazard, by definition, it is blight. If vegetation blocks a traffic sign, by definition, that's blight. So the question is that a $25 per day fine or is that a $50 per day fine? And because we can go up to $100 for the enabling statutes, I made it $25 per each element of blight with a limit of $100 per day. The ordinance that I just passed out clarifies and simplifies the procedure for issuing blight citations so that the recipient will not have to go into the enabling statutes to figure out what he has to do. When I prepared this final version that I have just passed out, it is intended to be sufficiently complete that after it's been reviewed by an attorney, in my opinion, it would be ready for adoption. And I support its adoption. I believe that the town does need a blight ordinance, but I think it needs one that is excellent. And I'll be happy to answer any questions.
Thank you for your comments. I believe Mr. Bancroft, you did want to speak next.
Sure.
Thank you.
I just had two comments. Mark Bancroft, Director of Administrative Services for the town. In Section 6, I think the ordinance is something that we need to help in our fight against what little blight we have. We don't have a lot of blight. There are a lot of trash issues that have a lot of blight, but it's always good to have an extra piece of ammo in our arsenal. In Section 6, Item B, The proposal says that the Blight Appeals Committee, consisting of 3 residents of the town, appointed by the mayor and approved by the town council. I don't know if you need it approved by the town council. There's only 2 instances that the mayor makes an appointment that is approved by the council, and that's the town clerk and the town attorney. So I might recommend that you remove that. And then in response to Mr. Priester's comment, in item D, any person who does not deliver a mail written demand for a hearing within, the ordinance says 21 days, and the statute says 10 days. So in order to make item D in compliance with section 7152C, you need to change 21 to 10. Other than that, I think the blight ordinance is a good thing to have. Thank you.
Thank you. Anyone else? Mr. Cherry.
May I, very quickly,
Yes.
the first of your comments, Mark, was incorporated as part of Public Act 146. That was part of the attorney's editorials. That was incorporated.
Okay, thank you. Good evening, Mike Cherry, 5 Whipwell Drive. I'm also chairman of the Planning and Zoning Commission in Ledyard. I'm happy to see this coming to public hearing and to a vote tonight. It's been a long, hard, arduous path. Some of the comments I saw in the paper and online indicate that people thought we should look at other towns' ordinances. I applaud you for seeing that and doing that over the last 6 or 7 years. House Bill 5319 was passed by the legislature as Public Act 12146, so they are in fact the same. Once again, Mark stole some of my thunder. Couple of simple corrections. In the first paragraph, under purpose, town and may threatens should be threatened, not threatened. It's a tense error. Had to have one of those.
I disagree.
Okay.
I believe the grammar's correct there.
All right. In section 2, paragraph 2, the ordinance shall apply to the maintenance of all properties now in existence and hereafter, and excludes agricultural lands as defined in section 22.3 Bravo of the statutes. 22.3 Bravo is a very general definition of agricultural land, and I would say that, one, I don't know why it's here. I think it's a carry forward from ordinance that we looked at as a draft. And 2, if there's a barn that's falling down in a public way or a house that meets the definitions of blight, I think agricultural land or an R20 lot, it's the same. It's still blighted, and we ought to have the option of using the tool to fix it. There's 2 periods after paragraph B in definitions. I agree with Mark. There's no need to send this Blight Appeals Committee to the Town Council for approval. The mayor's adequate.
That's been taken out.
And the reason there's 3 is a tie vote fails. So I don't see a problem with having 3. I would have a problem if it was 4 or 2. But you and your infinite wisdom would make sure there's an odd number, so that works for me.
I think Mr. Treaster's point was it doesn't address quorum. In other words, can 2 people make a decision or 1, or does it have to be out of 3? I had that same question.
Yeah, however you want to, whatever bylaws they adopt, right?
To address that, we left those kinds of issues to the commission's charter. So when the commission is formed, it will generate its own charter. It will decide issues of quorum, et cetera.
I looked at Public Act 146 specifically to make sure that our ordinance complied with it, and I thought it did, since the Public Act is incorporated into section 148 of the general statutes. I respectfully disagree with our lawyer, but he's a lawyer, I'm not, so I'll leave that where it falls. But he did, in his draft, he did pick up all the things that changed. Most of it's administrative on page 2 under section 4. When you renumbered, there's a lot of change bars, and he changed everywhere. I saw fines that went away, and it now says penalties. There was a comment that when you collect a fine, that may not fix things. Well, I would refer you back to Public Act 10-152, which has already been incorporated in the statute, but the statute now reads, making enforced regulations for the prevention and remediation of housing blight. The other thing that happened in 12-146, it allows for liens to go do that, and it specifies that liens for blight are first of any lien filed after 1997. And that shows up in the OLR report, and it's pretty clear reading the statute that it's there. So not only can you find somebody, use the statute and the ordinance to prevent blight by talking to them, but if you can't get it remediated, it allows you to put a lien on the property and remediate it for them. In my study on this subject, the legislature was looking at the ability to attach other assets of the property owner other than the property that's blighted. And I think that was probably trying to deal with things like apartment buildings that have been run into the ground. They have no value, so putting a lien on it doesn't fix it. You can attach their other assets. Go attach their apartment building on Park Avenue in New York City, put a lien on that, maybe they'll come fix the apartment. Thank you. I look forward to your passage of the ordinance now.
Thank you. Yes, sir.
Bill Burling, live on Sleepy Hollow in Galesbury. How many residents are there in this town?
15,000.
Pardon me?
15,000 approximately.
15,000. And
Residents or people?
according to residences.
Oh,
Residences. Oh, sorry.
6,200, 6,300.
Okay, so 6,200, 6,300. We'll go with 6,200. According to your definition of blight, how many residences meet your definition of blight?
I couldn't venture a guess.
I haven't counted.
No, I don't want guesses.
I think that's what we'd all have to do.
We all
Now,
guess.
okay, well, here's my situation here. I think it's really important that when you solve a problem, you solve a real problem. And to me, a real problem says you can carefully define your problem. And to me, carefully define your problem means you go through this town and you say, gee, I have either 50 houses with this blight problem or 25, because if I look at this, I would guess that you're way less than 0.1%. So I'm wondering, what problem are you really solving? Now, secondly, it bothers me when legal rules that we have to follow are too vague. And so when I read safety and general welfare, to me, general welfare is too vague. Then it says housing blight. Now, at least you went down here and you said blighted premises. But again, you have general welfare within the definition. And then you said it's not being maintained and contributes. Well, I can see how somebody would say this is not being maintained and somebody else is saying this is being maintained. So I have a problem with that. Is there a way to resolve these discrepancies that people might have and differences of view? Leaving the quorum to the commission, in my point of view, is not a good idea. Your commission really wants to execute the intent of the town. And the intent of the town, in my opinion, is to get a fair hearing. And if you leave it up to the commission, you're going to end up with problems. Because the commission may end up saying, I want to.
No, it still has to be approved by us.
Well, okay, let's put it this way. I don't care who approves it. I would like to see it in writing that it will be an odd number.
Well, that's what this ordinance says, that's why we.
It does say odd numbers?
Well, it says three. It specifically says three. So this is what sets the number of memberships, not the commission that would be formed to say, no, I want to.
Right, thank you very much, that's good, I did not read it that well. State of dilapidation, again, that's another term, that if somebody is really into order, then their definition of state of dilapidation may be different from somebody else, so that concerns me, that term.
In answer to that question,
Yes.
that's why we reference the definition of dilapidation is what the state determines,
Oh, okay.
not the commission.
And the state definition is a real good working model?
It's within the building code.
No, my question was, does it
Within the
really
building code.
define what dilapidation really is?
In the building code.
Well, there are many building codes out there that are not
One that we
very
reference.
good. Pardon me?
We reference one in the ordinance.
Okay, do you know what the state definition of dilapidation
Off
is?
the top of my head, I couldn't,
Okay.
spout it out verbatim, but that's why we didn't define what it was. We let the state definition of dilapidation.
All right, but that concerns me, okay?
Well, that's the state, not us. You
No,
know what I'm saying?
if you make it that way, it is the state. I agree.
Right, and that's why
But
we-
you can make it something else, can't you?
The state always.
The state said dilapidation shall be defined in accordance with section 117.1 of the state building code.
Okay. All right, I guess I don't quite understand how that works, and I apologize for that. Another comment was like, unable to provide shelter or serve the purpose. Again, we're back into that, what do you mean by unable to provide? That's all. Yeah, I started to get a little worried about physically hinder or interfere with the lawful use of abutting premises. Wow. Can you imagine somebody putting a wall on a perimeter of one's property, 1 foot in, so it's definitely on this property? Is that really a problem? I don't know. I'm asking that question. Can't people do something with their property that might bother the neighbor, but
But if it threatens public safety, in other words, if they put a wall on a curve and you can't see around the curve when you're driving down the road, and
that feels right.
Yeah.
But that's public safety, and that really feels right.
But that's what it's in there for.
Well, okay, well, I was just a little worried here.
And many of the things that you're bringing up are
Yeah.
the intent of the commission. That's why we have the commission who will deliberate about these things
Okay,
and make the decision.
okay. So I guess the last thing is I'm a little worried about my boat. A boat is got to be stored somewhere. Oftentimes boats are worked on, and is that going to be declared a blight?
Because it took boats on.
Pardon me, you don't have boat in here.
We
so-
don't, we really, when in the scheme of things, a boat sitting on a property being worked on is not a blighted issue. If it's a point where the boat is, if there's a boat on there that's basically decaying itself back into the ground, that becomes a junk issue that's covered by zoning,
That feels right, but.
not blight.
Yeah. So I
Blight is
guess
more-
it's the question of where does blight come in here, and I'm a little worried.
That's what we worked on it.
That's why we worked on it for so many years.
Yes.
So I would love to see, with these parting words here, this group get some data that lets us know how much of a real problem we have here, or how much this is just not a problem.
Well, Mr. Burling, if you live next door to somebody trying to sell their house, and the house next door to them is blighted, they will tell you that there is a problem. If
Well,
that's just two or three people, it's a problem.
This council doesn't worry about individuals. I think this
We do.
council is
We
more.
worry about everybody.
Well, in my view of the world, the council should be addressing larger issues, which is things that affect all of us in a collective sense.
Okay, I'm sorry, I'm going to cut it off here because I shouldn't have started a debate. Thank you very much for your comments. We've got lots of other people
Are you
here.
going to get some numbers?
I believe we feel, and the reason we're at this place is we feel the problem is enough to require a blight ordinance.
So you're not going to get numbers.
I have no intention.
We could, without understanding what again, going back to the commission, that the actual blight commission, who are going to be the ones who make the final decision on whether something is blight or not, we don't even have that commission in place yet. So we could not go around town and make that determination.
Well, why are you creating an ordinance for a problem which you can't even define, and you can't tell me if it's really a problem?
Okay, I can.
With real
I
hard
can.
numbers.
Mike France and I, Councilor France and I,
Okay.
when we were traveling through Avery Hill last year campaigning, not last year, but the previous year campaigning, saw at least 6 houses that were under foreclosure, that were no longer being lived in, that were going
Out of 6,000.
6 in one neighborhood.
That's 1/1,000.
In one neighborhood.
Okay, so I'm asking you to please go to the town and using your.
Mr. Burling, we have lots of people that want to speak.
Okay.
Thank you for your comments, though. Anyone else would like to speak this evening? Sir.
Good evening, Mr. Weshi, 19 Gallupo Road. I'm also retired from the zoning commission, along with Mr. Treaster, and I think for a long time. And some of my comments actually might assist here. If I could just pass some photos out to the commission, to the council, kind of define what life looks like. There's perhaps enough to go around there. My wife and I moved to Ledyard in 1984 and built a house in Ledyard, 19 Gallup Hill, and actually sold the property you're looking at as part of the subdivision to a gentleman who did a very nice job of building a beautiful house. We had looked at property previously in Ledyard, and one of the things that steered us away from that property was looking out the back to the neighboring property where we saw a bunch of junk cars lined up. And I believe Mr. Davis, you're in real estate, so you understand what people are looking for and what they're not looking for. We appreciate the efforts of the town council to create a blight ordinance because I can't pick my neighbors. I sold the property to a gentleman who did a very nice job of building a beautiful house, and the pendulum was swung 180 degrees in the opposite direction when the gentleman who owns the house now has created what you see there. This photograph you see here is a Google Earth satellite picture taken from miles out in space 2 years ago, I believe, 2011, I believe is the copyright on this picture. The problem has actually increased. So I think my point is that I believe the town, and having sat on the zoning commission, one of the things we took to heart was working for the residents of the town, to ensure that their property values are protected. And I think one of the things that this ordinance does is just that. Somebody coming into the town who might move in, like we did, next to a beautiful house, can now rest a little assured knowing that there's some protection in there that prevents what you see in front of you here. This is, I think, is an extreme example of what can happen if there's not checks and balances in place to stop this before it goes any further. We've seen a lot of stuff on the zoning commission. I know that this is just, I think somebody used the term ammo in the arsenal. This is just one more thing that allows the town to put checks and balances on this type of blight this type of business. I don't even know how to describe it. The type of thing you might see around it. This is unpleasant to the eye. To the gentleman's point here, you don't have to drive too far around town. This is actually a little bit off the road. Some of the photographs you see in the multi-picture, those were actually taken off my deck. So if I was to try to utilize my deck and sit and look, that's what I get to look at off my deck. You can drive around town, you don't have to go too far, just down the road. You can almost go in any direction, and you will see something, whether it's a pile of garbage next to the house, it's old cars rotting away, perhaps causing an environmental issue. But I don't think you have to go too far to realize that this is going on. The gentleman's point here, you don't really have to look too far. I think you said 6 houses in one neighborhood. That's just what you saw. It was obviously enough for you that stood out in mind. So I applaud the efforts of the commission, the council. I would hope that you would enact this piece of legislation, this ordinance, and that I believe, having looked at it, that the checks and balances are in place to anybody who is in disagreement with what might be facing them does have the avenue to address that. Okay. Any questions?
Thank you for your comments. Anyone else like to speak at this time? Yes, ma'am.
My name's Sharon Peeler. I'm on the zoning board of appeals, but really don't know that much about that stuff. I would like to thank the council for giving me an opportunity to speak tonight. I do stand in objection to the proposed ordinance after reading it at this time, and for numerous reasons. Like anyone else, I do find that to be problematic. But due to a failing economy at this time, and the second article of the Constitution, this ordinance as written is a larger problem for the town. I am not so young to have not seen real life the last time there were serious economic issues facing the country. At that time, it was the norm for young men and boys to buy junk cars and fix them up. It gave them activities to do and actually taught them a useful trade. A lot of them wanted to work as mechanics. I know several of them when I was a teenager, born now mechanics. I don't think that all the parents of teenagers in this town either can afford to purchase cars off the showroom floor. So this practice would be one that would be the norm to my way of thinking. Now, as to my reference to the Constitution, as Americans, we are guaranteed freedom of speech and, by extension, expression. I personally find the Victorian homes in Norwich to be ugly. The colors in many cases are jarringly different than the choices commonly made today. But they are an expression by the owners, much like what people grow or decorate yards with. We as a town must also accept that we are a multicultural town, and that none of us is an expert in what all other cultures value. I have sat in meetings of the RTC where repeatedly we have been told that this ordinance is intended to give the town grounds to enforce banks to do upkeep on foreclosed property. I even heard tonight, to some extent. This does nothing alone about that issue, and does sound in reading as neighbor being turned against neighbor. We are in a very difficult economy. A resident trying to just hang on because of this economy is going to be far more adversely affected by fines of $175 a week than a bank is going to. Banks are going to just go, Ledyard is a small town, and to be more resident-friendly should not be forcing this issue at this time. I have heard far too much about how these changes will affect property value, especially at a time when those values are more controlled by factors outside of a property owner's control than I have heard about quality of life. This ordinance is more about superficial prettiness than about making this town a town to want to live in and be part of. There are very real issues in town that should be addressed first. Fire hazards like all those woods along the road that are filled with trees falling down, half of them leaning into the road now from 2 hurricanes. Nothing's been done about it. There's one up on Pumpkin Hill Road. Every time I go by it, I'm afraid that next gust of wind is gonna have us across the road, and maybe across the cars. I too see a great deal of garbage going around on trash collection days. Some of it's pulled over by roaming animals, others just blown by the wind or dropped by the truck itself. If there's a blight ordinance, who gets the fine for that? I do want to see something in place, but I think we need to be honest with what we're trying to do before we start putting ordinances in. Now, my son actually came across an article in New Canaan News by the blight ordinance officer in that town in 2010. The title of the article is "Blight Enforcement is a Slippery Slope." I only have one copy, and we'll leave it with you so you can read it, because he does also mention several of the things I did, and I didn't know about this article until an hour after I wrote my thing that I wanted to say. So I'm kind of struck by the fact that the blight enforcement officer is running up against what I saw as being issues. So I would appreciate if you did take a look at what he says.
Thank you for your comments. I will just mention that junk cars are under zoning, not under the blight ordinance.
It's mentioned in the ordinance I
It
read
is,
this afternoon.
but the junk cars typically would be covered under the zoning ordinance.
They're already illegal. You can't have more than one unregistered.
You are allowed to have one hobby car.
Yeah. But that's current regulation.
It's already on the books.
But this reads you can't have any. I think you need to read back on what you've got. It just says junk cars, period, not a number,
I know what it says.
okay? That, already have one friend who's panicking because her husband's been trying to rebuild a car for years.
She shouldn't
thinks he's
panic.
gonna have to get it fixed.
If
So,
Thank
we
you.
read the ordinance and
You said it says junk cars with an S.
it can be
junk
junk cars
cars,
is covered all over junk.
junk cars are already covered by zoning.
Okay?
And what this car actually doesn't say junk cars. It says debris. It's under the definition of debris. And it says junk comprised of equipment such as automobiles, parts of automobiles, furniture, appliances, cans, boxes, scrap, metal tires, batteries, containers, and garbage, which are in public view. So,
Okay, but automobiles are cars by any other term.
But
But it is
says junk
plural.
comprised
junk,
of
it specifically talks about junk. If somebody is rebuilding a vehicle at a hobby, they're taking a '57 Chevy and they're rebuilding it, and it's all just a rust bucket now, and believe me, I understand that. That's not junk if you're actually working on restoring the vehicle. That's not junk.
If it's been there for 25 years and nobody's touched it,
That's junk.
I don't think anybody's been watching a particular thing for 25 years, to be honest.
Which is, but,
But,
and the
now,
other.
as to the other thing, Alan, we did bring up the sailboats, just to throw it out there, people watch all the different decorating magazines and gardening magazines. I have seen boats in that condition used as garden bases.
And I know there's two on Shoeville Road, too. And the other point that you made about colors, nowhere in this ordinance do we talk about that if I decide to paint my house pink, that I'm gonna get a blight
I'm just
enforcement.
using that as an example of
Right.
one man's trash is another man's treasure, one man's beauty is another man's nightmare. Okay?
But nowhere in this,
We cannot
nowhere does it
stand
talk
in
about,
judgment and expect to be a town of people that are comfortable.
Thank you. I know, it's hard, we want to get into debate here.
let me just say this. I will agree that blight is a very subjective term. Absolutely. Which is the purpose of the commission, who will always be controlled by statutes and ordinances already on the books.
I'm just gonna say again, please read that article before me.
Thank you. You have it here, and we're
This is
passing it
something
along.
that actually is in that position. We've had to deal with these things.
Anybody else like to speak this evening? Mr. Treaser, I'm going to let you go last, if you would like to speak. Anyone else? I'm going to give you 2 minutes. Oh, I'm sorry. you're not limited, you haven't spoken yet.
Well, thank you for not putting a limit on it. Prescott Thompson, 1981 Route 12. That means I can exceed 5 minutes with no problem, right, Linda?
I don't know where the 5 minutes came from.
I don't know either. I've never heard that. But anyway,
It's supposed to be 3.
I spoke at the last meeting, and you guys made some great changes and have cleaned it up quite a bit. But going back to the original point, and it was brought up a couple of times, what problem are we trying to solve? And don't tell us it's out there, define it for us. Show it to us. Now, I have another problem with that thing that you're about to hold up. You can't present that in this meeting because you didn't present it publicly beforehand. So right now I've heard many people talking about this is in the ordinance, that is in the ordinance. What is the date, draft, and time of the ordinance you're voting on? Because the word fine is in the one in that public hearing.
We have the draft ordinance that was out for public, that everybody has seen. But what happens now is at the end of this meeting, we'll end the public hearing. We can make changes.
You can make changes.
Yes.
My point is you are now getting ready to talk about an ordinance that we haven't seen.
No, you have seen.
No, we haven't, because the word fine is in the ordinance on the town portal. Councilor Eichenberg says it's not in the ordinance. So where is this other ordinance coming from?
Do you want to clarify, Steve?
I will clarify. This goes back to the lawyer's editorial comments,
Okay.
which all enact Public Article 12-146. Now, as Mike's Cherry already made the statement, Public Act 12-146 is already defining or helping to define Connecticut General Statute. What is it?
And Steve, I'm not concerned about the numbers. Just the concepts here.
When I spoke with the attorney yesterday, what he said was, yes, you've already defined it, but just to be careful, take these few terms and elucidate it a little bit further.
So you've made changes to what you posted for a public hearing and have not revealed that to the public.
No, we are not.
No, Linda, he just said he did.
Let me clarify. If he confused you, let me clarify. We will be voting on the ordinance that you have seen.
No, I'm talking about the fact that you are talking about an ordinance that is not posted for this public hearing.
We will be voting on the ordinance that was posted to this public hearing. I expect we will make changes, which we are allowed to do.
So in other words, this isn't a public hearing. This is just for you to go ahead and vote on the changes that you want.
No.
You have not presented to this town the facts. You have not presented to this town what ordinance you guys all know you're talking about that we don't have a clue.
No.
So that's my opinion. I'm going to leave it at that. I'm going to
say
say that right now I don't believe you're holding that public hearing. I believe you're holding something else. That something else is because you guys have all these information that we don't have. There's something wrong with that in a public hearing. So, with that said, I am against it now because you don't seem to be sharing everything. If I can't read about it before I come to this meeting, how can I speak on it? How is it right for you guys to have changes you already know you're going to do that we don't know about? That's not right. That's not a public hearing. Thank you.
Thank you. Mr. Cherry.
I'll be very short. I'm not a member of the town council. I don't receive correspondence from the town council. Yet, what was posted on the public hearing, I did my homework. And I realized it said, go look at 7-148, so I did. And I found out Public Act 10-152 or 252 and Public Act 12-146 changed it. And that was effective in October. That was a comment that I made at the last public hearing, that there was a new act that modified the statute. So I was well aware of what was in your ordinance. I applaud the fact that you've gone to an attorney so that Mr. Prescott doesn't have to do the research I did. You've elucidated, go look at this other piece of paper that modified it a bit.
The problem's not
The other thing I would say is the term housing blight, by my review of other towns' ordinances, and I think probably your review, is a generic term. and does not refer to a residential property sitting on a piece of land. It's a general term that defines a condition.
Thank you. Mr. Treaster, I know you have a comment.
Since he did call me by name, I would like to respond.
You can respond, and then Mr. Treaster.
Okay.
Thank you.
This isn't a problem with the ordinance and the numbers. It's the fact that the word fine is in what you guys are not, it's not in what you're looking at, but it is in what we're looking at. What else is missing? We don't get to see what you're looking at. So it's not posted there, the word fine is there, and you guys talk about an ordinance where it's not there. That's the problem.
It's referring to the November
Go ahead.
14th, which is the first one that actually came out, and that's probably why.
Fine,
And then made some changes.
the change in the word fine is one of those things that Public Act 146 changed.
So you made a change without posting it for the public hearing.
Oh, wait, we have to make a change.
We have not changed anything. We have not changed anything.
The word's different, it's not there anymore. You can't tell me you didn't change it.
We have not changed anything. Let me clarify something. Anytime you hold a public hearing on any board, commission, and include the town council, if the body of what is being proposed, if the preacher can attest to this, and so can Mr. Terry, that is what we're looking at. We, as the body, when we go into deliberation to vote on it, can make, but let me finish, can make minor editorial change as long as it's not substantive changes to the wording of the language of the document.
My objection is that you guys already know what the change that you want to make, and I would say that changing the word fine is not minor. Making it in compliance with state statutes when it wasn't before is not minor, but you don't bother to tell us about that. That's my problem.
What we're looking at here is a document that's been posted legally. We're all looking at it. We also have input from, let me finish. We have input from an attorney. We intend to change that document at this meeting tonight, or possibly a future meeting. But we have that authority to change the document, just as we have the authority to change that document based on anything anyone here says.
I totally agree you have that authority, but why didn't you post it before when you knew about it before?
Well, if someone here says, let's change something, and we agree, do we then have to have another public hearing? No, we don't.
Yeah, you do.
No, we don't. That's what this hearing is for.
This isn't a public hearing on this document. You guys have referred to another document not available to the public. It's been referred to by Councilor Eichelberg, Councilor Dubrowski. I haven't heard you refer to it, or any of the others, but it's been referred to. Where is it, and why can't we have it before you have a public hearing?
We post all documents received on IQM2. That's one document that's up. We also have Mr. Treaster's comment.
That's right.
Those are also posted.
I've read those, and those aren't the ones that these councilors are referring to.
We're talking about the attorneys. The attorney who reviewed this has provided us with a document. It is public information.
It's not posted.
And we will
It was not posted in accordance with the time frame required for the public hearing.
But we didn't post Mr. Treaster's.
Yes, Mr. Treaster's comment, well, at least half of them were of it.
And we're also not going to post all the comments that we heard tonight.
You made a significant change to a document without posting it.
If we were to substantially change the document to completely change the wording of it and the meaning of it and the definition of it, you'd be correct.
You did.
But since what we've been told by our town attorney and the information that was received late yesterday afternoon, wait, let me finish, will you? It are minor editorial changes to a document that we have the ability to do. The zoning commission could do it, the planning commission could do it, the combined planning and zoning commission could do it, any commission that's voting on a public hearing document. As long as the changes are minor and editorial, it's okay to, if you can change it during the deliberations.
I absolutely agree. I'm not, that's not the point I'm debating, Kevin.
But the
I'm
point,
saying
but
that
one of the
you
things,
made substantial changes by taking the word fine out. That is a substantial legal change in terminology.
we changed the word fine to penalty.
That's right. It's a
And that's
substantial
an
legal change.
That's an editorial change based upon what the statute says.
This
Mr.
is very-
Treaster, you have a couple
Anyway,
comments,
very brief.
and then we'll be finished,
Yes.
I believe.
I appreciate it. First of all, I am disappointed that the changes were not available when you became available. I did a lot of, when I reviewed the proposed ordinance, I was not aware that the attorney had made changes to this draft. And
They recommended changes.
He did not.
which
We can
will
ignore
discuss.
them all.
Right, yeah.
We can ignore them all.
Second is Kevin and I have always been trained that during public hearings, we are supposed to be open-minded and neutral at this instant in time. We can have opinions, but we are required to be open-minded. Second is the statement was made tonight that dilapidation is defined in the building code, and I respectfully disagree with that. If you go to the IQM2 documents that I entered, and you go into my detailed comments, I included a copy, word-for-word copy of the dilapidation section from the building code. And if you look at that closely, it is not a definition. It is what it is. For no other reason, the word dilapidation is used in the paragraph itself, which obviously we never use the word that you're defining in the definition itself, except as an example of how to use the word. But I urge that you take a very close look at that before you approve this proposed ordinance. There are approximately 7 pages of analysis that I put into this document. I urge that instead of just simply going with the attorney's guidance and saying, yep, it'll take the word of the attorney over everybody else, I urge that during the deliberations later on this evening, that you look at the IQM2, look at my comments, and look at the rationale for those comments. Because I don't just criticize, I give the reasons for those things. And they are exhaustive. The proposed ordinance that I passed out is based upon the Hartford Blight Ordinance. It is vastly superior to what has been proposed before this evening. Vastly superior. And I urge that you look at the two and see if you really, really want to do this. The other thing is that I've heard over and over again tonight the word commission, and I'm assuming that you're referring to the 3-person commission that will hear appeals to the blight hearing officer. The blight hearing officer is limited to only one job, and that is to make a decision if there is or is not blight. Two things: is or is not blight, and was the blight citation ordinance implemented properly? That's it. The blight hearing officer is required to be neutral. He's a judge, and that's his only authority. And yet I hear over and over again that the blight commission is going to be writing blight procedures. Those procedures should be in the ordinance. It's in the Hartford ordinance. It's in the zoning citation ordinance. It should also be in the blight ordinance. They all come from the same part of the statutes. And I urge that you take a very, very close look at my concerns. Okay, I did not go into those concerns to save time during the public hearing, but they are real, all online, and I have also included the enabling statutes in those comments so that it ties it directly, line by line by line by line, as to what's wrong with the proposed ordinance. Attorneys are not always right, and if you have the slightest question, get a second opinion. This is probably the most important ordinance this town will ever adopt. Do it right. Thank you.
I have a question. Mr. Treaster?
Yes.
I'm trying to find where you're distinguishing between dilapidated and dilapidation. And is your point that dilapidation is not defined?
That's correct.
Okay. And is your suggestion that we change the word dilapidation to dilapidated because it is defined?
No, I'm saying you don't need that. You don't need the definition. If you look at my proposal, I don't define it. It's not the only thing that's required by the enabling statute that absolutely has to be defined, and it has to be defined very carefully and very right with consensus, is the definition of housing blight. Nothing else has to be defined.
Mr. Allen?
Yeah, Mr. Treaster, I know you made mention of the Hartford Blight Ordinance, and I would dispute that by saying I don't think anybody in this room or in this town probably wants to be Hartford. The second thing is going to, and I read your 14-page commentary on it, as well as your definitions in the revision. Section 6 definitions, item 6, you talk about what it involves, what is blight, and it talks about interior walls. Now, I have a really hard time trying to regulate somebody's interior walls, particularly when it comes to a blight ordinance.
Our purpose is not to regulate. Our purpose is to prevent and mitigate. If you also look at that definition, it requires 2 of those 15 items
I understand
to be subject to it. That is word for word the same out of the Hartford ordinance. The Hartford ordinance is relatively new, and I think it is more precise. I think it is more objective. If you don't have that, so be it. Right? If you haven't seen it, then you can't use it. But if for some reason you do have access, for some reason you do have access to get into the property, and you discover that the inside walls are deteriorating, now you can kick off that item on the list. Doesn't mean you have to. By the way, that brings up another point, and that is the enabling statutes do not permit the blight enforcement officer to enter property. Okay, and that should be in the ordinance.
Thank you. Does anyone else have any comments? I'm going to close this public hearing. We have another public hearing, so we're going to take like a 2-minute break. Don't anybody here go anywhere? Okay. I'd like to call the second public hearing to order. At this time, the council clerk will read the call of the public hearing. It's all right, and then we'll have a presentation by the Finance Committee, and then we'll open it to public comments.
The Ledyard Town Council will conduct a public hearing at 6:45 p.m. on Wednesday, January 9th, 2013, in the council chambers, Town Hall, Annex 741, Colonel Ledyard Highway, Ledyard, Connecticut, to receive comment on the proposed ordinance establishing a retirement plan. At this hearing, interested persons may appear and be heard, and written communication will be accepted. Copies of the draft ordinance are available in the town clerk's office during regular business hours. Dated at Ledyard, Connecticut, this 17th day of December 2012, for the Ledyard Town Council, Linda C. Davis, Chairman, published in New London Day on December 31st, 2012.
Thank you. Mr. France.
Very briefly, the proposed ordinance essentially cleans up a number of ordinances that we've had on the books. The opportunity here was when the defined contribution plan was brought into effect for the town. It brought an additional ordinance defining retirement plans. So what this ordinance does is makes a very good attempt of taking all the ordinances dealing with retirement plans in the town, codifies them in a single ordinance, and then supersedes the previous ordinances to define a generic retirement plan and allow the plan documents to give the details of what's involved, so you don't end up with this potential conflict between a town ordinance and a plan document that could change. And certainly when that plan document changes, if you have incorporated language from the document into the ordinance, now you incur the cost and administrative burden of trying to maintain multiple ordinances in compliance with a retirement plan document that can change relatively easily by vote. And it's not, we really want to get to a point where we're dealing from a generic sense of retirement plan as an umbrella and we point to the plan document. So that's the intent of what this one is doing, and that's what we're on.
Are there any comments from the public? Any comments from town councilors? We'll close this public hearing. Okay, now we're going to take like a 2-minute break because we're going to take a 2-minute break. That was just like a warning shot.
Yeah, tell me. Yeah, no, that's the wireless router.
Yeah, see, there you go, right. See, there you go. There you go.
That's what my objection is. We can go 100 if I get inside of that. Well,
I'd like to call this town council meeting to order. Please join me in the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation,